Thank you very much for such a warm introduction. Can everyone see my screen? Is the
Yes.
PowerPoint up? Great, thank you. And thank you very much to the conference organizers for having me today and accommodating me online. I very much wish to be there, not just for the amazing educational program, but for many of the social activities, which I'm sure you are all enjoying. So I'll begin with my presentation. I will try to keep it as short as possible. I know we are pressed for time. So really, my topic is the greening of contracts of carriage of goods by sea, a topic very closely related to my PhD research, which looks at the incorporation of climate change goals as well as environmental regulation into private relationships within the shipping sector. So really my main thesis question that I'm going to pose today is, do we need an interpretive set of green principles for the interpretation of contracts of carriage by sea? So that is my main question, and I'm going to break it down into three further sub-questions, which will naturally guide what I'm going to be discussing today from a structural perspective. So my sub-questions are, do green obligations in the current regime exist? And yeah, I'll be looking at the Hague-Visby rules and the Rotterdam rules to see what the present regime is and where there are any environmental obligations that might exist therein. I also look at how are environmental standards being included in present contracts as obligations, and are these current clauses sufficient? And then finally, do we need further directional guidance on how to interpret these obligations in the event of disputes, and also to further advance the goals of converging objectives in terms of environmental standards and the achievement of climate change targets? So at the outset, I probably need to really narrow down the scope and explain what I mean by contracts of carriage. I'm not referring to all contracts of carriage because that would take far too long to include every type of contract in a comprehensive discussion. So for the purposes of this investigation, I'm talking really about voyage charter parties and time charter parties. And this is really because I'm looking at where negotiation between owner and charterer takes place. So where is there real equal bargaining power? Where do we kind of have two big parties who can agree and negotiate on environmental considerations? And we know that often the terms of the charter party are simply reflected in the bill of lading with smaller cargo holders. So in terms of the bill of lading, when you offer these to small cargo holders, these are often take it or leave it scenarios. So the negotiation powers and the bargaining powers are not always as equal as we see with some of the bigger charter arrangements. And then my analysis is done within the context of English law as the chosen law for governing chartering relationships more generally, but obviously relevant on an international scale. So moving on to my first question, do green or environmental obligations presently exist in the current regime? So when it comes to the Hague-Visby rules and the Rotterdam rules, there is no real reference to environmental obligations. However, when it comes to the Rotterdam rules, Article 7 does state that a carrier will be relieved from liability for loss of or damage to the goods, as well as for delay in delivery, if it can be proven that reasonable measures to avoid or attempt to avoid damage to the environment caused or contributed to the damage or the loss. So that is encouraging in terms of the Rotterdam rules, where we see that reference to delays which might be caused by environmental considerations or protection of the marine environment. We also need to consider the obligation of seaworthiness. Now, this obligation necessarily considers external circumstances, and these must include environmental standards and necessary documentation. And even on a traditional interpretation of seaworthiness, we know that a ship must have the degree of fitness which an ordinary, careful, and prudent owner would require his vessel to have at the commencement of her voyage, having regard to the probable circumstances of it. Now, that can arguably be extended to some of the environmental requirements of a vessel. But do these rules, in fact, sometimes hinder environmental performance? We also need to consider the obligation of due dispatch and the obligation to deliver the vessel within a reasonable period, not having unreasonable delays. So what does this mean for things such as just-in-time arrival or slow steaming for the purposes of fuel conservation and emissions, the reduction of emissions? So perhaps there are some hindrances, and the IMO has noted this in saying that when it comes to just-in-time arrival, contracts should not hinder the ability to perform just-in-time arrival. And I'm sure the same will be noted in terms of slow steaming, where we need to formulate our contracts in such a way that we do not hinder our ability to do such things, which would delay the arrival of a vessel. So it becomes very clear that these rules, the Hague, Visby, and Rotterdam rules, are primarily there to govern commercial arrangements. So they all essentially come down to the allocations of risk, responsibilities, and costs, whilst environmental interests more generally are viewed to stem from the public law regime. So we kind of generally view these agreements in isolation from the overall environmental milieu and the public law regime which governs them. So how are environmental standards being included in present contracts? So what are shipping associations and private parties doing at the moment in order to handle the increasing environmental standard setting that is taking place? When it comes to ballast water management, by way of an example, Intertanko has endorsed 2 broadly worded clauses for dealing with ballast water management in respect of both voyage charters and time charters. And we know in charter parties, it is generally the owner who warrants that various requirements of the Ballast Water Management Convention are met. And this is because in terms of the convention, owners need to ensure that their vessels comply with the various surveys for certification in order to avoid detentions and fines. Charters might want express clauses to protect them in the event of non-compliance, especially where this results in time lost, where ship owners might want to compromise for a reasonable endeavors obligation. So these things are all considered by Intertanko. When it comes to the sulfur cap, we know both BIMCO and Intertanko have been quite instrumental in trying to incorporate environmental standards into charter agreements. The BIMCO 2020 Marine Fuel Sulfur Content Clause for time charter parties includes a warranty by the owner that the vessel shall be compliant with sulfur content requirements, where on the other hand, the charterer shall supply compliant fuel and warrant that bunker suppliers, bunker craft operators, and bunker surveyors used by the charterers are also compliant with the requirements. Intertanko also has an all-encompassing bunker compliance clause for time charter parties, which takes a much broader approach to the requirements of MARPOL Annex 6. Also in May of 2019, both BIMCO and Intertanko released contractual guidance for vessels which are to be fitted with scrubbers. And this was for compliance with the 2020 standard. And this guidance looked at key issues which both owners and charterers should consider in contractual negotiations. So we see there's lots of work being done in how to incorporate these standards into these private relationships. But I really ask the question, is this sufficient? Are these mere bilateral ways of viewing these relationships sufficient? Or are they narrowly focused? Do we need to do further work in this area? So what are some of the insufficiencies or inadequacies with this viewpoint? So there is an assumption that non-compliance will be attributed to the behavior of either of the contracting parties. This fails to consider the intervention of third parties, such as equipment manufacturers or procedurally inaccurate port inspection schemes. These contractual clauses also deal with issues of environmentalism as a regulatory hindrance, as opposed to a convergence of ideals. Control is an important part of governance, but it does not go far enough to influence real change and expectation when it comes to environmental objectives. And then we still have the issue of split incentives, especially in time charters, where the owner covers the costs of fuel efficient or energy efficient technology, but the charterer bears the benefits of reduced fuel costs. So how do we evaluate these relationships in terms of green performance? Is there a better way than simply viewing these as market-orientated agreements that are simply centered on things such as allocation of risk, responsibility, and costs? So although the shipping associations have provided us with some useful clauses and useful guidance on how to consider environmental standards, do we need to go one step further? So a more appropriate question might be one of interpretation rather than incorporation. So we already know what incorporation looks like, thanks to these shipping associations, which have cleverly drafted such clauses. But do we need a set of principles which might guide the spirit and purport of these clauses? Do we have any prevailing norms in terms of environmental governance, which might impact on these private relationships? So in the early days of a ship's life or vessel's life, we have finance agreements to consider. And here, the incorporation of environmental standards as well as objectives and prevailing norms is a bit more straightforward to implement because we have financial institutions as well as governments who are committed to a set of environmental ideals. The banking sector is under immense pressure to implement green frameworks. And their judicial body might be able to hold the bank accountable to its green framework, one in which it has publicly committed itself to. However, it's a bit different when it comes further down the line to further contracts in the vessel's lifespan, because we have multiple players who might not have all committed themselves to a similar green framework. So thus far, we can only interpret these clauses in a way that maintains the status quo, which is mere regulatory compliance. We cannot yet go further to incorporate a set of norms and values which might be pervasive throughout the interpretation of the contract. There is the consideration of implied terms, which might be something which occurs in the future. Thus far, a court cannot deem people to have subscribed to a certain set of green rules, as there are many interests and players involved. But a term of sustainability or greenness might be implied, although the vast majority of terms will be expressed. And we know that terms can be implied as a matter of fact, whereby an officious bystander test determines that certain things are so obvious it goes without saying. Yet they can also be implied as a matter of law. And here the courts will have regard to duties which prima facie occur in certain types of contracts, as guided by a matter of policy and reasonableness. So although the courts have not yet dealt with the emergence of green obligations or norms within contracts governing private relationships, there is some potential here for environmental considerations and environmental rights to become more pervasive, especially as the climate change agenda is afforded priority status in public law regimes. So such terms could also become customary, and many environmental lawyers would argue for the elevation of an environmental duty to become tantamount to the principle of good faith. We are also seeing increasing horizontality in the application of environmental rights between parties, especially where environmental rights are enshrined in constitutions. More and more so, we are seeing private parties held to these constitutional standards. Therefore, having a green convergence of ideals and objectives would be considerably beneficial, especially within this context, in guiding the spirit and purport of how environmental standards are contracted in chartering arrangements. So it would be much better in the long term to have this sort of normative and pervasive guidance going forward. But this is all very nice to hear about in theory, but what would it look like in practice? How would we use a green framework or green set of environmental norms to guide industry behavior and also to assist judicial bodies in the event of disputes? So what would this look like in practice? Really, we would see energy efficiency as a negotiated term. So this would be something considered at the outset, as I spoke about previously, where parties have equal bargaining power. And this would be in such a way that At the inception stages of the chartering process, there is some incentive for an environmental commitment from both parties, providing a means for distributing energy efficiency costs and rewards, as well as providing clarity on the rights and responsibilities of the parties. There's also been much talk of nudging lately, and this really refers to a theory whereby you make optimal information available to all parties involved. So in respect of a direct nudge for emission reductions from shippers, fuel consumption and CO2 emissions per distance traveled per cargo is essential. This is premised on the idea that if freight forwarders could access reliable data pertaining to the emissions resulting from the carriage of their cargo, then they would be enabled to choose less polluting options. We also see an increasing integration of financial products and schemes into charter parties. So this is where banking frameworks, financial frameworks that are endorsing green principles really make their way into charter party arrangements. And common ones, or not common, but maybe more well-known ones that are quite pioneering, are the Save As You Sail mechanism. So this was done by the work stream of the Sustainable Shipping Initiative together with Deloitte and HFW and University College London. And they formulated a scheme whereby the owner and the time charterer benefit from the cost savings resulting from investing in retrofitted energy saving technologies. So under the scheme, the owner of a vessel takes out a loan with the finance provider and agrees to regular SES fee with the time charterer on top of their charter rates. The owner is therefore apportioned some of the cost savings made by the charterer, which can be used to offset loan payments for the retrofitting. There's also the self-financing fuel mechanism, which was formulated by a number of interested stakeholders, including the Carbon War Room, PwC, and UCL. And this really is an important financial model integrated into the charter agreement, which has two important features: a guarantee of fuel savings from the technology vendors and a refined data collection methodology, which continuously monitors equipment to accurately quantify and verify fuel savings. So in terms of financial products, here we can implement green principles from a financing stage, as banks are strongly encouraged to apply private governance mechanisms for environmental protection. So we can see a trickle-down effect from the financial phases of a vessel and its inception financing agreements to its charter arrangements later down the line. So moving forward, there's definitely a lot of work to be done in rethinking some of these bilateral agreements. In my opinion, they can no longer be viewed in isolation from a set of public law norms, as environmental factors are increasingly being considered in private contracts. However, the effectiveness of such incorporation will depend on effective interpretive and guidance to direct the spirit of these clauses. So thank you very much for listening. I will conclude there. Thank you.
Thank you very much, Pia. It was really a very interesting area of research and an excellent presentation. Now we are opening the floor for any. Pia, could you please just close your.
I will do
we'll
so.
Have a gallery view. Are there any questions for Pia or for?
Sorry, I'm
Maya
just struggling to.
Albano? Let me try if I can do the gallery.
Doesn't seem to be allowing me to stop the function. Oh, there we go. Stop share. Got it.
Okay. So please, do you have any? Professor Maria Piazza has a question for Albano. Maria, please.
Hello. So I have a small question for our colleague Albano. So did you have a chance to compare insurance clause with from BERCON 2017 with previous solutions from BERCON 2001? So which solution is better for the parties, for the owner and for chartering? BERCON 2001 or BERCON 2017? Thank you.
sorry, but do you can repeat? I can't hear clearly.
Okay. Maybe Maria was too far from the microphone, or maybe this
sorry.
would be better.
Okay, thank you. Okay, so I was wondering, did you have a chance to compare close insurance from Berkon 2017 with previous solutions from standard form Berkon 2001? So which solution is better for parties? Thank you.
Okay, yes, I have the opportunity to compare, and the Berkon 2001 is similarly as the Berkon 89 form. So the solution is the same as provided for the Supreme Court in the Ocean Victory case. Regarding the question of what option is better, I think that in the one hand, regarding the bareboat charter, in the practice, the solution is the same, because although there is no an exclusion of liability in the bareboat charter, at least the insurer still be deprived of bringing a subrogative claim against the charter because of the circuity of action theory and the theory of the insurance term. On the other hand, where we can see a big difference is regarding the subsequent charters and subcharters, because in the Berkon 89 form and the Berkon 2001, the insurer have no claim against the time charter, for example. But now the clause 17 of the Berkon 2017 especially states that the insurer would have a claim against the subsequent charters. For that reason, at least the only modification in the practice is that.
Thank you, Albano. I think the next question comes from Achim for Pia.
Thank you very much, Professor Bio. I don't know if it's a question or rather comment. I mean, I really liked your presentation. Thank you very much for that.
Yeah.
And I mean, I think this greening in general is of course a very up-to-date topic. And I mean, perhaps one can relate it to the corporate social responsibility tendency in corporate law. Since ships usually belong to corporation, perhaps this is also an issue which might be important. Legislation has recently changed in Spain to include a non-financial report in the annual account, and one of these things the corporation has to talk about is precisely the environmental issues. And then there's a second question, which has also quite recently been introduced in Spanish legislation, which is the possibility to let's say, attack a company which does not comply with its own compromises in this matter by way of unfair competition law. I mean, if you have some kind of code of conduct or something like that in which you assume to apply certain environmental standards and you don't apply them, so at least in Spain this would probably be an issue of unfair competition, because it really is an issue of deceit of customers if you don't comply with your code of conduct. I mean, since you are analyzing this topic from the point of view of the contract and shipping law, perhaps this is not the most important issue, but I think the tendency is clearly there. Thank you very much again.
Yeah, if I could just respond to that, I mean, what you said is incredibly important, and I think it affects all private relationships. Especially we're seeing an increasing relevance when it comes to disclosure requirements for all companies, especially financial institutions. And I think why it's becoming so relevant to shipping contracts, or when we get carriage of goods contracts in particular, is because ship owners are basically beholden to finance agreements, which originally have these green principles, which need to then trickle down into their further relationships with charterers. And it's very, very interesting area that's evolving quite rapidly in terms of disclosure requirements, especially you see in the area of climate change litigation. And there's some really exciting work taking place there where companies are being sued for their carbon outputs and for not reporting accurately. And in some jurisdictions, and South Africa is one of them, you can hold them accountable in a court of law to standards that they themselves have taken on and committed themselves to publicly. So yeah, I completely agree with what you said. And I do think that in these particular commercial relationships between ship owner and charterer, we have to start looking at these things and what it means for charterer ship owner relationship because of company disclosure requirements and because of the initial finance agreements where these principles might stem from. And then can we eventually get to a point where we have a prevailing set of norms which governs the sector in terms of environmental objectives? I hope that kind of comments or answers on some of what you were saying.
Yeah, of course. Perfectly. Thank you very much.
Okay.
Francisco has a question.
Yeah.
Professor.
Good morning, everyone.
Good morning.
Congratulations to all the speakers for the great presentations. Well, my question is for Maja Junovic. Well, it's a tricky and complicated question that you explained. Well, one of the most relevant problems here in Spain is the possibility to enforce the maritime liens or mortgages directly to the ship once the bankruptcy is declared, okay? Because we have a special measure in our bankruptcy law that considers that the certain assets as an essential assets to maintain the activity of the debtor and don't allow the enforceability of these assets. For example, the sale of the ship during the bankruptcy procedure. What happened according to the law of your country?
Thank you for your comment. If I understood well, it's impossible to sell the ship in the bankruptcy proceedings if it's the only source of income and the only asset of the company, right?
Exactly. Only in the final step of the bankruptcy process, okay?
Yes, I came across such provisions, and I think also UNCITRAL model law also covers partially this part, but in Montenegro we don't have such provisions. So actually we don't actually distinguish. And while I was preparing my presentation, I was aware that most of bankruptcies of ship owner will probably result in such case, but it's not regulated in my country, nor even in the practice.
Okay.
Thank you for your comment. It's very useful.
Thank you to you for your presentation.
Thank you.
Thank you, Professor Torres.
Okay.
Maya, are there any other legislations that was very interesting in the example of Maltese maritime law with ring fencing of maritime means? Have you found any other national laws with similar solutions in your research?
I think German legal system has a similar provision for sure, but it was interesting to see that some of legislation system definitely give rights to give priority to maritime law, but only up to the moment when bankruptcy is declared. And after that, bankruptcy actually, I mean, they make it to be dependent on the moment of which procedure started first. So, but I think Germany has similar provisions. USA, for example, has completely different regimes which usually collide, and I think they are that jurisdiction which actually gives rise to bankruptcy more than maritime liens enforcement. And I think it's because of their practice, because they hosted actually very big shipping lines companies bankruptcy procedures, and that's where that kind of revolution started actually. And in this situation, but for sure I would apply Maltese provision because I find it completely clear, and this shipping I mean bankruptcy of ship owner is always a problem. We cannot really eliminate possible issues, but I think it solves many issues. Thank you for your comment.
Thank you, Maya. Are there any other questions for our speakers or comments? If not, I would like to thank all of them. Also Massimiliano, who is not with us at the moment, Maya, Albano, and Pia for their very, very interesting presentations. Also, thanks to all you who were following and participating in this discussion. We will now take a coffee break.